Hello, Craig. How are you?
I'm well, thanks. How you doing?
I'm fine, thank you. You're a new guest for me. It's my first time ever interviewing you, and I'm really excited to meet you and to talk to you today because we have a really exciting case where you are defense counsel and you successfully defended your client in this case. It's the Rush case. I know I was advertising about this case a lot on social media because I really think it was a fun case to read, although disturbing when we'll get to talk about what the issues were here. Before we get into it, I know a lot of people know who you are. You're a very senior and renowned criminal defense lawyer, but I'll let you introduce yourself with your own words.
Hi. Uh, yeah, I don't know what else to tell you. My name's Craig Bottomley. I'm a criminal lawyer. I've been practicing for about 23 years. I practice out of Toronto. I do a lot of charter litigation. I do a lot of homicides and criminal organization trials, and occasionally I win, which is, it's a little bit like golf. You hit one good shot, enough to keep you coming back for more. And I don't know what else you would want to know. I got not lucky on this case, but I was lucky to have Sebastian Becker, who's my associate, who did a lot of the background work and wrote the notice of application and wrote the factum, and I got to go in and stand on his shoulders and take all the glory after I cross-examined these cops and beat them up a little bit and make passionate submissions to Justice Jones,
Yeah.
but it was because of the groundwork that one of my colleagues, Sebastian, at the firm's called Bottomley Vanderhayden, and he's a bright light. He did some nice work on this.
Well, that's very nice. And congratulations to both of you. And obviously, you did a really good work. And His Honor Justice, we're talking here about Justice Brock Jones, who was the judge who gave the decision here. He obviously understood and agreed with your argument. I think it's pretty difficult not to agree with it, and that's what we're going to be talking about. So this is the Rush case. It's a pretty recent case. I see here it's from September 12th, 2025 that we have the decision. It's a charter case. Or we're going to be talking about the charter aspect. I know it continued a little bit afterwards, but now it's completely done. So
Done,
congratulations.
done. We
Yeah,
can talk
it's
about it.
done. We can talk about it. And we're going to be talking about the charter application here because it was pretty shocking. Even for, like criminal lawyers, we always read charter applications. So we know that cops will make all kinds of uh I don't know if it's a mistake here. I don't even know how to describe what happened here in this case, but it was almost like they took everything from every charter case that we know and they put it all combined it all together
It's
in
very
this Rush
thoughtful.
case.
Yeah.
It's too much. And as we were talking before we started recording, that this is after 40 plus years of charter litigation that we get this kind of case is a little bit disturbing. So
Yeah.
let's talk a little bit about the facts of the case,
Sure.
Craig.
So, my client is alleged
Mr.
to be
Rush. Yeah.
Mr. Rush is alleged to be the landlord or the sort of the superintendent in this building full of students at York University. It's off-campus housing, just south of the campus. And one of the young ladies that lives there goes to the police and says, "Hey, this guy's doing some creepy things, and he's without getting into all the minutia, basically he's coming into my apartment when he's not supposed to, and I have a recording of him doing this," which she kind of did, but it didn't show quite what she purported that it showed. And the police sort of didn't pay any attention to this at first, and then some detective picked it up, a month or two after the initial allegations, and went back and looked at it and called her in for another interview and spoke to a few more tenants. And so they decided they were going to arrest this guy, and they were going to look for things that support the things that might support the case in the home. But when they get their ITO, I honestly have no idea how they messed this up as badly as they did, because they just put, like, the address is 123 Sentinel Road or whatever it was, and they go to 456 Bottomley Street, and
Right.
uh, you know, uh, nearby, but not the same house. So
No,
this
and that's the thing. Like I have the decision here. So the two addresses that we have, like they're not even it's not like they
house not
mess
even
up the
close in
number
shape.
and the
No,
road
no.
name. It's 27 Aldwinkle Heights, and then the other one is like 39 Haynes Avenue. Like
Yeah.
nothing to
And that
like.
was the one that they wanted to get into. They go to Aldwinkle, they get it
Mm,
wrong. And, what must have been terrifying for the occupants of that home, because this whole squad of, geared, well, not geared up, they weren't wearing tactical gear, but, vests and badges, and they go in and quickly realize they're in the wrong place and they've got it all wrong. So they abandon ship, they abort the mission, they go back, they get a new ITO, and they're like, we messed that one up, and they go to the right spot. And then when they go in, so the first thing that we see on, a couple of them are wearing uniforms and body worn cameras, and one of them is this sergeant who goes into the basement. My guy is on the top floor, according to their intel. And he goes into the basement where there's this, young Asian student, like she can't be more than 20 years old. And she's sitting on her bed, and this officer comes through the door and watching the body cam footage, points a gun at her. And so in cross examination, did you have your gun out? Yeah, I might have. You might have. Yeah. Okay. Well, did you point it at the young lady that was in that room? No, no, I never did that. I always kept my gun in the Sewell position, doing his Mel Gibson
mhm.
impersonation. And I said, "Oh, you sure about that?" Yeah, absolutely sure. Okay. Let's watch the video
Yeah.
where, you know, you point and you see that point where you pointed at her head. He goes, well, it was definitely up a little bit. I don't know if I pointed at her head, and I had gotten a still from the footage and said, you see your sights, that little notch there. Yeah, what's on the other side of that notch?
Yeah.
It's her face, right? You're pointing the gun at her face, and
And
so
obviously, he knows that Mr. Rush is a male and he's there because of Mr. Rush, not because of that female
no,
student. Yeah.
like she couldn't be more different.
Yeah.
And so they do this, they clear the house and they get upstairs. There's a locked door to the third floor, which they take down with a ram. There's a door between 2 and 3. So they take that down. They go upstairs. And these two officers, the two guys that arrest my client, they're roughly the size of Cadillacs. And they
Mhm.
take my client to the ground, handcuff him. And this is on like a creepy landlord
Yeah.
case. This isn't like a gun
Drugs.
case. There's
Yeah.
no violence, there's no drugs. This is like he came in my room and I think he's been surreptitiously recording me.
Hmm.
And so they go in, like gangbusters, take him down, take him to the ground, pick him up, and then on one of the body worn cameras you can hear one of the officers saying, "What are the codes to these other rooms?" Because they're all code controlled to get into the student rooms. And my client, like in a panic, gives them the information, which is incriminating for him because it shows
Yeah.
he knows how to get into the rooms.
Yeah.
But they haven't told him like why he's under arrest. You can speak to a lawyer. You have a right to remain silent. And it's kind of threatening because in addition to him being like tackled to the ground and handcuffed, they say, if you don't tell us the numbers, we're going to kick in the doors. And so there's this sort of atmosphere of oppression. They then search the room. They find a long gun, like a hunting rifle that he has no license for, and then they find a cell phone that has clearly not been used. It's a cracked screen. It's on this shelf. It's not in his pocket. And the officer like powers it up, turns it on, and starts like searching around
Hmm.
on the phone with
Without a warrant.
no warrant and none of the precautions from Fearon, right? Like no notes showing like the directories he goes into, no notes explaining why he's doing this, why it's urgent, nothing. Um, and then having done all this, they put my client's in his pajama bottoms and handcuffed behind his
And
back.
this is in December.
It was in December.
Hmm.
And they put a hoodie over his shoulders. They can't zip it up because his hands are back and it's too broad with his
Yeah.
hands. He's too broad with his hands back. And they, instead of zipping it up or doing anything, they march him outside. Everyone else is wearing like a winter jacket and a
Yeah.
toque, and that's one of the areas of cross. I'm like, what are you wearing, officer? And I'm like, I'm wearing this winter jacket. And
Yeah.
what's your partner wearing on his head? That's a toque. And
Yeah.
what's my client wearing? And he's like, standing there with his chest and stomach exposed, and the transport that they thought was gonna be there was not there. So they're standing outside for like 10 minutes in the freezing December weather until finally they put him in a car and he's like shaking
And
away.
was that captured on the body worn Okay, that's great.
Yeah, and the 10B is lackluster at best. So they've got like just a a problem from start to finish. So we end up getting the utterances and the phone and the firearm all excluded. The firearm was obviously a big deal, but also so too was the phone, where they find a bunch of recordings that would have been a real difficult thing to explain had it gone to trial. So, and as you and I discussed a little bit, I think that's the importance. Like, I don't have standing on the prior search, and I don't have standing on the behavior in the basement, but it painted a real picture for Justice Jones to see, like, if you're looking at the pattern,
Yeah.
like we might have not have standing, but it colors the 24-2 when you look at the absolute callous disregard for the way that the charter and their responsibilities under the charter are approached. So that's the blueprint of the case.
Well, and it's not just that, Craig, it's also what they said, well, the lack of notes or
Oh
what
yeah,
they said about their notes about this other search. Like, I think one officer didn't give them to the Crown, and just when you asked him, I think in cross about that, he said, well, I didn't think it was relevant to the case or something to that effect.
and it wasn't just one of them; it was all of them because they all said, "I'm like, did you make notes?" And their answer was always, "I would have, not I did." You would have. I see. Did you disclose that to the Crown? No, I didn't. Okay. And we get to the end of day one, and Sebastian writes a disclosure request to the Crown saying, please
Yeah.
obtain and hand over all these notes, to which we get an email back. There are no notes. And then a very fair Crown attorney on the other side of this, really good guy named Scott Arnold, gives us, of course, an agreed statement of fact saying, a request has been made, there are no notes. So I get to stand up in my submissions and say every single one of them lied to you.
Yeah.
They also, like, the charter breach continues to today,
Hmm.
because in this court they are still obfuscating their conduct in this case. And the charter breach, it wasn't confined to the 45 minutes that my client was under arrest and at the house and giving statements and having his phone searched. It was 2 days earlier
Yeah.
when they searched this, and it goes up to the trial today where they're lying. So, and I think that resonated with Justice Jones.
Definitely. I mean, like, there's very strong language in the decision. It's a very fun decision to read because obviously the judge didn't buy any of what the officers were saying, and it's clear that they were in big trouble here. I mean, and it is concerning because it's, as you said, like, even if there are parts of it where you didn't have standing, but it's just too much, like too much, and it started before they even got into the place where they were supposed to be. And I mean, thank God that there are body worn cameras because I guess that played a major role in your favor because you're able to really, like put it in the cop's face that they're clearly lying here.
Yeah, I mean, it's always the double-edged sword for the defense, right?
Yeah.
Like, I've certainly gotten body
Yeah.
worn footage, or I remember I had this kid,
Yeah.
he's a young black man out of Scarborough with two other black men out of Scarborough who are actively drinking in the car while
Yeah.
they're driving. There's 2 pounds of weed and a firearm in the trunk, and in front of a marked cruiser, make an illegal left turn that leads to a stop, that leads to a search, that
Yeah.
leads to my client hilariously shoving one of his compatriots out of the way as he
Yeah.
runs away. And when I read through the notes, I'm like, well, this has got to be crap. Like, there's no way that these three guys drinking, or this driver drinking in front of a cruiser,
Yeah.
illegal left. Like,
Yeah.
this is a pretext stop. I get the in-car
Yeah.
video, the big, like, do not turn left in reflective metal directly in front of the car, directly in front of
Yeah.
the user, and the car turns left, and I'm like, well, shit. Uh, and the,
But
and
is it clear? Can we clearly see that it was your client's car and it was him? Because that
my
could,
no, my client's in the back seat. The problem is he's the one that, as they're about to search the
yeah,
bag that has the gun, that's when he shoves his friend
yeah,
into the cop and takes off running down the street. I lost the trial, is the
yeah.
point. Poor Ricky. But but the these they cut both ways, because sometimes you get the video where there's a clear charter breach. I just had one up in Newmarket a couple of years ago where they turned off the camera but forgot to mute the mics when they got
Oh
back in the
no.
car,
Yeah,
and two police officers actively conspired to breach the charter for about 2 minutes. It was the most fun cross-examining a cop.
yeah.
He emailed me afterwards asking for tips. Like, it was great. So we have this tool, and it's a real good truth-seeking mechanism, because you're going to find out the unvarnished truth of what happens. And a lot of these officers, like, they have this confirmation bias where they're on the side of angels. So everything they do, like, they may very well believe what they did is the way they're saying it. And then you get the camera and you're like, oh, what about this? And it blows the case open. But those are very, very dangerous witnesses, because they believe what they're saying to be true until you get the objective eye of the recording.
Well, and they were getting away with it for so long without the body worn cameras. I think like there were a lot of issues that were happening, but because it wasn't caught on camera, and some judges maybe tend to, I mean,
Sure.
like we want to believe that they're here and doing their job and protecting the public. But then when you clearly see and you're confronted by this video that clearly shows that what you're doing is not what you said you did, then it becomes a problem. And just going back here to the point that you were mentioning, Craig, about the body worn cameras, that it could be a double-edged sword. And yes, I agree that when it clearly captures the wrong and criminal behavior of the clients, it's a problem. But the issue is still, at the end of the day, these are clients, right? Like they're not state actors, so, or agents. So at the end of the day, a normal citizen screwing things up is one thing, but when it's a cop who's screwing things up, I think that's really serious. And the problem is that when it's normal people who screw things up, we hear a lot about it in the media, and then their reputations are destroyed for the rest of their lives. But when it's a cop, it seems like, oh, okay, well, they messed up. And then they move on to the next case, and it seems like nothing happens. And that's
Nothing
what I
does.
find is outrageous, because I don't think that these cops like were affected by this case after, like, but that's a problem. I mean, don't you?
Yeah.
I find it outrageous. I don't know what you think, but I find it really outrageous.
The example I just gave you, we're up in Newmarket. The officer uh, was um, was asking me for tips after he got destroyed in cross examination, and all the drugs got thrown. It was a lot, fentanyl and cash and a
Yeah.
gun. Like, it all got tight. It was
Yeah.
really bad. Then, so he happened to arrest another one of my clients in very similar circumstances 2 years later. I went back and trashed him again. The Crown halfway through was like, "Oh, we're staying the charges."
Yeah.
He was a sergeant when I went back. So the first time around, he was a DC.
Yeah.
He gets destroyed. The
It
Crown.
doesn't prevent him
No,
from,
he's a sergeant now. When I did a case up in Barry slash yeah, it was in Barry, and my client, was an obnoxious drunk driver, and two police officers dragged him out of his car and beat him half to death. They beat him to the point that his own father didn't recognize him at the hospital. Okay, it was brutal. There was an independent witness to the beating, and she was a Crown attorney, and she swore an affidavit saying, this is what I saw. Like, she came to
Mhm.
my office and signed off, and maybe I went to her, but either way, she signed off on this affidavit saying, this is what I saw. And so I file, an abusive process, excessive use of force, real serious charter application. And the morning of the trial, the Crown pulls the charges. Um, That fast forward, you can look it up. There's a case I argued. I swear to God, the name of the accused was Harley Davidson.
Okay.
And Harley Davidson had a son who was autistic and like a little boy, like 2, 3 years old. And one day, Harley takes a nap, and his kid gets through the special security lock that they've got to prevent this kid from escaping because he's a bit of a runner. And he runs down to the corner of a pretty busy intersection. And someone knocks on Harley's window and says, "Hey, your kid's down by." Oh my God. Runs down. By the time the police arrive, the kid is wrapped up in a blanket in his mother's arms. Harley's there. Kid is safe. Okay, everything's fine. Police say, "We better come back to your house and make sure it's safe for children." So they go back to the house. Harley goes to shut the door. They jam their boot inside, say, "We need to do a welfare check." And they walk around, non-consensual search,
Yeah.
no search warrant. There are very specific provisions where the CAS can go in for a welfare check. They don't meet this test. They walk around. They ultimately find a grow up in the basement.
Hmm.
One of my colleagues at the time, a very, very good lawyer named Chris Suratin, goes in and
Hmm.
does the trial. He unfortunately he had a judge that not great on reasonable doubt, and
Hmm.
our client is convicted. I go to the Court of Appeal, and the Court of Appeal thoroughly overturns this judge. Like, it is very, very strong language. The cop that put his boot in the door and came in it was one of the two guys that had beaten my client half to death, and he'd been promoted to a sergeant.
Hmm.
It was the exact same thing. And there are no repercussions.
Yeah.
There's nothing. They don't, to the cops. If my view is, as long as they get the gun off the street, as long as they get the drugs off the street, then good job done. They don't. There's not this great care for the charter that which is why you need defense lawyers. This is why we're here. It's as I often tell the judges, I'm not here standing up for my client who had the 3 kilos of fentanyl in the trunk of his car. I'm here standing up for the 50 guys that look just like him who got pulled over for no good reason before you got lucky and found my guy.
Yeah. Yeah.
That's the gig.
Well, and one thing that I also, and I don't want to take too much of your time, but I do want to talk about this point because I feel that sometimes the sense, I may be wrong, but the feeling that I get sometimes is that in the public in general, there doesn't seem to be that much appreciation of those rights that we as defense lawyers try to protect all the time in these cases. Like, I don't think that the
Until you get arrested.
yeah, exactly. It's true. But I feel like it's too bad that they don't realize how important these rights are and how important it is to fight to protect those rights. And these charter cases just show to what extent, like I was reading this Rush case and I was just so outraged that all of these things were happening and they kept piling on. Like there were more and more and more breaches that were happening. But it's like we talk about these cases, but unfortunately, the public won't talk. We see them talk a lot when there's a victim, a lot about the victims, and which is fine. I'm not saying the victims shouldn't, you know, but still, there are a lot of people who are accused and who are treated badly and who don't get their rights respected. But it's not a big deal. And I just find this outrageous.
If you want to make it a big deal to the police, there's a way to do it. No one will ever do it, but there's a way to do it. And that is, in addition to excluding the evidence, start awarding costs against the coppers that
Hmm.
have breached the charter. Now they'll never do it,
Yeah.
but it would end it. We'd be they'd be like, "Oh, hold on, I can be out of pocket for the lawyer fees here if
Yeah.
but they're never going to do that. So, but that's how you fix the problem. But until someone gets arrested, like you remember when that very high profile case at Nathan Phillips Square in the underground parking where the police officer gets run over by the gentleman who is like palpably innocent.
The Zamir case?
The Zamir
Yeah.
case. And thank God he had Nodder as his lawyer and does a
Hmm.
great job
Yeah.
and he's acquitted. But you have like politicians weighing in and saying, "Oh my God, this is disgusting." It's like there's very little respect for the presumption of innocence, and there's very little, respect for the charter until it's you. And I find like the other people that care are judges, and a lot of crowns too.
Yeah.
But we're lucky to have a judiciary that include judges like the one I had in the
Yeah.
Rush case. But
Yeah.
I've made my living for the last 20 plus years doing charter litigation, often to a very receptive audience, and it's not just in the progressive hub that is Toronto. You often go out to these smaller jurisdictions, and judges out there are very receptive in a lot of cases, and very critical of police behavior. And so those are the people that care. But I find there's, for me, nothing more stressful than a truly innocent client.
Yeah.
If I lose one of these cases, well, maybe you shouldn't have had the 3 kilos of fentanyl in your trunk. Maybe you shouldn't have the recordings of the students coming out of the wherever. And but when I did like the Rebel nightclub homicide as a double homicide, my client was legitimately innocent. He was
Hmm.
guilty of something else, perhaps, but not murder.
Yeah.
And that case took. I remember showing a client of mine a photo with I had this photo with a UFC fighter, and he was a big UFC fan. I'm like, oh, check this out. And I showed him the photo, and he's like, oh, who's that? And I'm like, well, that's BJ Penn. He goes, no, who's beside BJ Penn? I'm like, that's me. He's like, oh, what happened? As he looks at this
Yeah.
graveyard. And I'm like, that goddamn Rebel nightclub case, that's what happened.
Yeah.
It took years off my life because, when you're dealing with legitimately innocent clients, it's far more stressful than the guy who had his rights breached, that you get to stand also on a moral high ground and say, I'm here for the 50 guys that look just like him.
But even the rights breached is outrageous.
Absolutely.
That's what I find, that people don't seem to care that much. Oh, well, his rights, whatever. There, it's not just your rights, whatever, like
No,
that's
because
what,
labeling people as a criminal in the media is easy, right? It's
right.
very easy. Like, how many cases have you done where the arrest gets a huge splash in the papers? Oh, rapist
Well,
caught.
the Zamir case is a perfect example because at the beginning, before this guy got to trial, the public was really against him. And that was based on the comments that were made in the media and by politicians that were trying to paint him as this criminal cop killer.
And then
But
when he's
then
acquitted,
everybody felt really bad for this guy. They realized like that
at
was a,
least at least for him, there's some news about the acquittal. And the trial itself is very high profile. But I've done 100
yeah,
cases where there's been a huge splash about the arrest, and then I win the trial, and there's no press
yeah.
when the guy walks out of the courthouse a free man. It's very rare.
And you can't erase all the press
No,
that
it's there
was
forever.
there that was talking, like saying all these bad things about your client at the beginning. And that's what's so unfortunate. And that's why I find it it's outrageous that these cases, whether they're innocent or not, it does have an impact on their lives. It does change their lives. But on the other hand, when cops screw up, like you said, they get promoted. They then keep on going. They go higher. They and nothing seems to happen, which I think is really unfair. I
It is
really,
unfair. And my client on the Rebel nightclub case had to change his name,
yeah. Well, I'm
right?
not surprised. Yeah, not
Uh,
surprised. And
so
sometimes people have to leave. They have to go live somewhere else if it's a too high profile case and they're really painted in this very negative view. It's really sad. But that's why I really encourage everyone to read this case. It's a fun decision to read because, like you said, you luckily you had a really good judge who also really ha used very strong language in this decision to just.
yeah, he wasn't happy.
He wasn't happy. I know. It's very obvious. I mean, you just have to read the decision, and he was clearly not happy. But it's a very interesting case to read because it's fun. It's actually a fun case to read, not one of these
He's a very good
boring.
writer.
Yeah,
Yeah,
yeah.
it's
Well, and there's a lot of drama in this case.
that
Like
was a good one. The
it's a
cross
very
examinations were fun.
yeah. Yeah, it's too bad that we like it's not recorded because I think that would have been a really like a textbook cross-examination for people to watch.
You can order the audio.
Yeah. Yeah, it's true. Like this is something that I really encourage everyone to read the Rush decision, to watch this interview, to reach out to Craig to talk more about this. And obviously, Craig, this is not your last time. You have you said like your career is you've been doing charter litigation for a long time, and I really hope that we'll get more and more of these decisions, and we'll get to. I hope you'll come back and we'll talk more about them because this is a really fun decision. So again, congratulations to you and to your associate who worked hard, you said, together with you on this case. And I really hope that we'll have you soon again for another fun case like this one, the Rush case.
Well, we're gearing up for a pretty high profile one, so stay tuned.
Oh, I'm very happy. Looking forward to that. Thank you so much.
My pleasure. Thank you.